Welcome to the presentation called Pitfall Potpourri Employment Edition, brought to you by the Law Society of Yukon's Continuing Professional Development Committee. We have 65 people registered for today's event presentation, and we are very happy about that. My name is Tom Elliott. I'm the chair of the Yukon Employment Standards Board. And I would now like to introduce to you each of our speakers. So to begin with, we have two speakers today. Elizabeth Reid of Fasken in Vancouver, and I'll just give you a little bit of a bio on her, not the least of which is that she is a member of both the Yukon and BC bars. She practices in Vancouver, called to the BC bar in 2006 and the Yukon bar in 2015. She has extensive experience as both on the solicitor side and the advocacy side of labor law, employment law, and human rights law practice. And she, as you can well imagine, in this complex area of law, she is right in the thick of it, helping clients to navigate employment and labor and human rights laws and regulations and rules and policies and directives governing the employee-employer relationship. She provides help to her clients with day-to-day concerns, compliant issues, and whatever other needs they have. She's represented clients at all levels of court in British Columbia, as well as in front of provincial and human rights and employment standards tribunals. So welcome, Elizabeth. Our other speaker today is Jocelyn Barrett. Many of you would be familiar with Jocelyn of Lamarche, Lang and Barrett. She has been working in Whitehorse as a lawyer since 2007, and she practices in the area of corporate commercial, employment law, and real estate. She moved to Yukon from Quebec in 2007, and she is a member of both the Barreau de Quebec and the Law Society, of course, of Yukon. She's a graduate, a proud graduate of McGill University, 1995, and she has a Bachelor of Common Law and a Bachelor of Civil Law. She also has a storied hockey career that you can speak to her offline if you want to. Okay, so those are our speakers today. Just before we launch into this, couple of housekeeping things. I will be acting as both the moderator and referee, if you will, today, watching the clock, knowing that we have until 1:30 Whitehorse time to go through the material. Our presenters have a PowerPoint. You might see this on the screen at this time. As to questions, I will be watching the chat room, and I'll make a note of the questions that come up, and I'll put them to the speakers when there's a pause in the presentation or the discussion. So without any further ado, I think what we'll do is we'll start with the first presentation. And Elizabeth, I believe that is you, but correct me if I'm wrong.
Well, that's quite right, Tom. I'll start us off, and then we'll bring Jocelyn in as well. So thank you very much for that kind introduction. I also wanted to give a little shout out to Bruce Warnsby, who contacted Jocelyn and I about putting this together. And so thanks to Bruce for bringing us here today with everyone, and to Lynn for organizing all the stuff behind the scenes to make sure this all works out right. So great to have you with us. Now, Jocelyn and I have been practicing in this area for a number of years, and so we happen to see, there are certain areas where people can really get themselves into trouble. And so our hope is that this presentation will help you become a little more familiar with some of those pitfalls and hopefully kind of navigate around them. We wouldn't be lawyers if we didn't put in a few little caveats. So obviously this is legal information. We can't do all your work for you, so it's not legal advice. The other caveat is really today we're looking at what I would call true employees. So there are all kinds of workers out there. You can get into independent contractors, you can get into appointed public officials, all very interesting, but our focus today is really on what we would call sort of true employees. So that's where we're at. As Tom mentioned, we have the chat box if you have any questions. We were expecting about 12 people, so we were thinking we'd have a little more interaction, but we have quite a large group, which tells me that either people are as fascinated by employment law as I am, or you all just need some CPD credits. Possibly a combination of the two. So, but we would like to try to keep it interactive at least a little bit if we can. So we do encourage you to ask those questions. We're happy to take them as they come. And as Tom mentioned, he'll let us know when there's one there. So off we go with pitfall number 1. So this is about jurisdiction, and the pitfall really, I guess, should more appropriately be presented as kind of getting the jurisdiction wrong. Now, if you're like me, sometimes when you hear jurisdiction, your eyes glaze over a little bit, and it takes you back to terrible times in law school, but it's obviously crucial. And why is it crucial? Because it tells you these important things. What law do I need to look at? I guess you could get into an argument of whether that's actually jurisdiction, but I sort of put it in this category. And then on the employee side, you need to know, where am I going to go to get a remedy for this client? And if you're on the employer side, you probably want to anticipate, okay, if this goes sideways, who am I going to hear about it from? And the key considerations here are kind of, I put them in sort of 4 categories. The first is the federal versus the territorial, as per the Constitution and the Yukon Act. For those of you in the provinces, obviously federal versus provincial. The second kind of category is the type of employee or employer. And I would sort of describe that as being like the personal jurisdiction over the parties. Who has jurisdiction over these particular kinds of employers and employees? The fourth category is, if I go back to law school days, I would call it subject matter jurisdiction, but basically looking at the kind of claim and the work environment. So what's the sort of nature of this claim or work environment? And then finally, the kind of law. Are we looking at a particular statute and trying to interpret rights and obligations under that? Or are we looking at the common law? Or is it a mix of both? So starting with federal versus territorial or provincial. So essentially, what level of government has authority? Usually the answer is going to be territorial or provincial. That's about 94% of our Canadian workforce. And under Section 18 of the Yukon Act, the government of Yukon has jurisdiction over property and civil rights. So that includes labor relations matters, employment standards matters, basically kind of workplace stuff, if I can put it that way, for provincially regulated employers. I'm always amazed when I look at those sorts of things. You think like property and civil rights, it's such a short phrase, but it encompasses so many different things. So that's the territorial. The federal jurisdiction, that's about 6% of our Canadian workforce. It's still a lot of employers though. It's about 18,000 employers, according to the government. Approximately 13,900 of those are actually small trucking companies. So companies that have kind of between 1 to 6 employees, and they're doing kind of interprovincial trucking. The vast majority of them are really big companies, and those big companies or big organizations are the primary employers of federal workers. So about 87% of the workers who are federally regulated work in companies or organizations of 100 people or more. So the single biggest group is banks. Others include telecom or broadcasting, road transportation, pipelines and postal services, and air transport. So whenever you think about jurisdiction, if you have people who work for First Nations, who work in a bank, who work with grain. I'm not really sure where the grain one comes from. The others are a little bit more intuitive, but grain, if they tell you that they're a reporter, they tell you that they're an airline attendant, then you need to start thinking about federal jurisdiction because it is very different law that applies and you're going different places. I've set out the reference for the Constitution Act that you might want to have a look at if you have any questions about that. Because we have a lot of self-governing First Nations and they are major employers in the Yukon, I'll speak sort of briefly to that. We did have a case in 2010 at the Supreme Court of Canada called Miltois, and that was looking at sort of this federal versus provincial regulation, and it confirmed the kind of the test for determining which level of government had responsibility. And essentially they said, okay, you need to look at the nature, the operations, and the habitual activities of the entity to determine whether it's a federal undertaking. And if you can't decide, then you have to go a little bit further and decide whether the provincial regulation would impair the core of the federal head of power. Now, in that particular case, they found that a childcare society here in British Columbia that was set up specifically to provide care for First Nations children was not federally regulated. So they said fundamentally, this is a child welfare agency, and the fact that it's specifically for First Nations children, doesn't displace that provincial regulation. Now, looking at our Yukon First Nations, many of them have all kinds of different support programs within their governments that could fall into the same kind of category. So you could get into, complicated jurisdictional arguments about whether, somebody who works in, say, the governance department, I think we're going to be pretty clear that those people are going to be federally regulated. But if you've got somebody who's maybe working in an elders program providing senior support or children, services for children, you might be thinking, oh, well, are we going to get into this complicated argument? And I think the short answer to that is that you could, but I would say what I'm seeing generally is a pretty practical approach, even since Miltois, saying essentially if kind of, and generally the feds are taking kind of the regulatory authority there, and it's not coming up too much in the case law. I did see one case where they were trying to make that kind of complicated argument to say, well, this particular employee of a First Nation is, is working in an area that's actually provincially regulated, and the adjudicator didn't have a ton of time for it. They kind of went, yeah, I think their eyes glazed over when they heard the sort of overall test as well. And they just said, well, you know what, fundamentally, this is all about the First Nation government and services it's providing, so we're just going to go with federal regulation. So that seems to be the trend and in that kind of area. And certainly, a number of our First Nations governments here have either torn to or been found to be federally regulated. So next type of kind of jurisdictional issue is what kind of type of employee or employer do we have here? And there is unique regulation for certain kinds of employers and employees. And I got into a really interesting rabbit hole preparing for this session on this. So, looking at federal or territorial public service folks, including government departments, agencies, tribunals, corporate and crown corporations. Those all have special regulatory regimes and complete statutes that kind of deal with their employment issues. So if you have somebody who tells you they're a civil servant, you need to go take it a little bit further, and it's going to be a little bit more complicated, and you may or may not be able to do anything depending on where they're working and what they're doing. Teachers also subject to special regulation. And this one is one I had not thought about, but inmates in work programs. Those folks are also subject to kind of special regulation. And I must confess, I hadn't even thought of them as employees, but they have been considered. So there's special rules for them as well. Some of these regs are not necessarily intuitive. If you are a federal government worker working in the Yukon, notwithstanding that there's a perfectly good workers' compensation setup in the Yukon. You actually go to Alberta if you're injured, which is kind of like a weird little thing that somehow the federal government has set up something with Alberta on that particular front. So just basically the takeaway from all of that is if you have a civil servant, you want to have a look at that really carefully and make sure you know where you're supposed to go and what law you're supposed to be looking at there. So the next one is, I kind of put this under like work environment and type of employee. And what I'm really getting at here is kind of the union versus non-union environment. About 30% of employees across Canada work in a unionized environment. It does vary quite a bit. I was kind of disappointed in StatsCan, frankly, because I went to sort of find some more information about that was specific to Yukon, and they didn't have anything about the territories. So I was I can't give you kind of something that was really specific to Yukon, but as a general rule across the country, 30% union, 70% non-union. But keep in mind that just because somebody's in a unionized environment doesn't necessarily mean that the kind of unionized laws or what we would, kind of refer to as labor relations laws and labor law, not everyone that's in a unionized environment is covered by the labor law. So there are exclusions. So you've got to think about, is this person actually in a bargaining unit and subject to a collective agreement, or are they excluded? And common grounds for exclusion include things like being a senior manager, or having access to and working with confidential labor relations information. So if you start to think about those kinds of things, if you have someone who is working in a unionized factory, but they are the assistant to the president, they're going to have access to collective bargaining proposals. They're going to have access to, the president's schedule, all the things that they're doing. They may be seeing documents going back and forth. Those kinds of people, you need to start thinking about, okay, are they in the union or are they outside? Because it does impact where you go and what you do and what law you look at. So this presentation, we could go down a whole rabbit hole about union environments, which would be fun, but a little bit outside our scope. So today we're going to focus on non-union environments, but I want you to know that that is kind of out there as well. And my other comment is, notwithstanding that everybody always says, oh, I'm going to call labor relations on you. Well, they're not usually calling labor relations. They're not actually usually talking about labor law. They're usually talking about calling Tom down at the Employment Standards Board. So, and then of course, the last kind of sort of high level topic of kind of where do we go and what are we looking at here in terms of the law and in terms of the bodies that are going to govern the law is, what kind of claim is it? So in employment law, you have this wonderful opportunity to be in all kinds of places at once. You can imagine a situation where you have, for example, a pregnant employee who's not showing yet, but tells the manager that she is going to be expecting a child. The manager decides, well, you're not worth it. Now we're going to pay you less until the baby leaves and forget about coming back afterwards. Well, you can probably get at least 3 or 4 of these different claims just out of that one fact scenario. You've got a potential, you've got human rights violations, you've got, if the reduction in pay is going under minimum standards, you're getting failure to meet the employment standards minimums, you're going to probably have a breach of employment contract, you've certainly got a breach of privacy. So you've got all kinds of options. So it's important to think about, what kind of claim is this, what kinds of claims are here. And once you've thought about those things, here's your options. All right, so the courts are pretty straightforward. You've got small claims under $25,000 here in Yukon, different amounts in different provinces for those of you joining us from elsewhere, but basically small claims, or you've got the Supreme Court. And then you've got the administrative bodies. So you could be looking at the Office of the Privacy Commissioner of Canada, the Employment Standards Board, the Human Resources and Skills Development Canada, also known as the Labour Program, the Canada Industrial Relations Board, the Yukon Human Rights Commission. If it goes further, the Yukon Human Rights Panel of Adjudicators, the Canadian Human Rights Commission, the Canadian Human Rights Tribunal, the Accessibility Commissioner, that's a new role at the Canadian human rights level. Workers' Compensation Health and Safety Board, Yukon Public Service Labor Relations Board, Federal Public Service Public Sector Labor Relations Board, Yukon Teachers Labor Relations Board, or the Workers' Compensation Board of Alberta. So basically. Now you also understand why we always just refer to it as either the board or the tribunal or the court, and we hope that you know what we're talking about. Because nobody can remember all these acronyms. But those are all the different options that you have. So hopefully I've convinced you that you need to look at this and make sure that you're in the right place before you go there. A couple of things to think about when you're looking at the jurisdictional issues. I think the first one is what avenues are possible, because not all of the bodies are able to hear all kinds of claims. Some of them are very specialized. Some of them have some overlap with other bodies, and others are completely exclusive. So you've got to think about, you know, is this even possible to bring my claim here? And if you're on the defense side, can I get this claim kicked out? And hopefully they won't try again if they're in the wrong place. Also, what's involved in bringing a complaint in that particular venue or forum? And I would suggest you need to look at, you know, what are the costs associated with that kind of claim? You'll see variations between, you know, in the courts, you know, the cost to go through a small claims procedure is almost certainly going to be lower than the cost to go through a Supreme Court hearing. The administrative bodies often don't even have a filing fee. Certainly in British Columbia, at least, it costs you nothing basically to bring the claim if you're on the claimant's side. So it's quite easy to do. You have to look at the time, and that is where it can be helpful to check in with the individual bodies or with a seasoned practitioner who can tell you, okay, what's the kind of general time frame we're looking at? Because in some cases, you know, a remedy that you're going to get, you know, 2 or 3 or 4 years from now is not as useful to your client as a remedy that you might be able to get in sort of 3 to 6 months. And that can switch too. I mean, a few years ago, I would have said, you know, if there was a way to, you know, frame your claim as a human rights complaint, you could get through quite quickly. These days, our human rights tribunal is completely backed up with COVID cases, and you can't get in. You know, we're starting to get emails saying, yeah, we know you're out there, sorry, we just can't do this, we're too busy. So you could actually, if you could get it, you know, sort of maneuver your claim into a claim that you could bring in the courts, you could actually potentially even get through faster. So things to think about. Procedural burden is another one that I think about. You know, many of the tribunals are designed for lay people, which I think is super helpful for lay people and frankly for lawyers, because it's, you know, we're lay, in some ways lay people as well. We could use those legal brains if we need them, but if it's nice and set out easily, then I won't complain about that at all. So that's something to think about, you know, how complicated is it to bring this claim? And the other thing that I mentioned is sort of the evidentiary burden. So in certain administrative tribunals, generally speaking, you know, it's going to be a slightly different kind of evidentiary burden in the sense of the technicalities of the evidence that you bring in. So most of the tribunals, because they're designed for lay people, you know, they're not supposed to be complicated. You know, they'll even have specific language that says, you know, we're not going to really apply, and we don't have to apply the rules of evidence. So everything kind of ends up going to weight. So it's rare for something, you know, to be excluded. It might not get a lot of weight, but it doesn't get kicked out entirely. Whereas at, you know, the Supreme Court level, you're really looking at specific rules of evidence and trying to deal with those. And you may have evidence that gets kicked out completely. The sort of third thing I'll say is kind of what remedies are available at the particular venue that you want to get to. So, and I would consider both the substantive remedies and cost awards. So are costs available? If you have, you know, a human rights suit and you've got some injury to dignity damages, that might be great. But if you're at the Federal Human Rights Commission, you know, those are capped at a certain amount. You might be better off, depending on what happened and how much the human rights component is a factor, to try to think about, well, can I make this, you know, a manner of dismissal kind of case, and maybe bring like a claim for compensatory and aggravated punitive damages in the court system? Would that be a better route, depending on what's at stake? So these are all the kinds of things that you kind of need to think about when you're deciding, you know, what to do and where to go. The good news is it's usually fairly obvious, but not necessarily. So important to kind of have that initial analysis. And then the final thing there is really, are you in time for that forum? You know, for certain places have very short timelines. For example, you know, at the if you're going to bring a complaint of unjust dismissal under the Canada Labor Code, you only have 90 days to do that. So that is not a lot of time. I think there would probably be certain people that would come out and realize, oh, wait a minute, oh, we missed that deadline because the employee, you know, hadn't even kind of figured out what to do yet. So you've got to think about, you know, what are the time limits, and are there issues there about where you can bring things. So that's kind of the high level stuff in terms of, you know, the kind of criteria or the things that I would think about when you're bringing a case. Now I think there's a little Q&A question up there. Tom, do I see something in the chat box there?
It's from Bruce Wormsby, one of the Law Society's favorite questioners. So, and here's the question, reading it word for word. So in terms of human rights, let's try again. So in terms of HR policy, a FN may need to have different rules for different employees, or would it be okay just to apply the higher standard? That's the question.
Sure, and that's a great question. I think you are safer to some extent if you can apply the higher standard. But the challenge kind of becomes when you get into actually bringing claims, because there are very different rules in terms of what kinds of claims you can bring and different rights, particularly for non-managerial employees in the sort of territorial jurisdiction versus the federal jurisdiction. So, you know, you can kind of mitigate some of the risk by just going with the higher standard, but they don't always, you know, completely align. So I think these days, you know, I would, you know, again, legal information, not necessarily legal advice, but what I'm seeing is that generally with our Yukon First Nations, even for the First Nations government itself, we're generally seeing federal regulation. Now, little caveat there, a lot of our First Nations have development corporations, or they have, you know, specific business operations that might be owned by the nation. Those are going to be territorial. Those are not sort of as integral to the government functions, the government operations. So those are most likely going to go provincial. So something to keep in mind. Am I, you know, when you're dealing with your First Nations clients, am I dealing with somebody in the Dev Corp, or am I dealing with somebody who's actually working directly for the nation? And yeah, could get into some interesting issues there. I just try to, you know, it seems like the general sense is that the adjudicators are kind of going, yeah, we're not going to do that. It's going to get too complicated. So. Okay,
Elizabeth, as you're pausing there, we have a question in the chat room. I'm going to read it. It's from Darcy Tachuk, and it reads as follows. When facing a situation where more than one forum is available to proceed, are there any particular pitfalls that may lead to prejudice if you choose one forum, i.e., could you be limited from choosing another forum, or find out you chose the wrong forum?
Yeah, another great question. And Jocelyn, feel free to jump in if you have thoughts on this one as well. I mean, my thought is that if there are multiple fora, and there's no particular area that you think would be better, I don't think there's anything wrong with starting multiple claims. You know, there can be strategic reasons for that, but it's always kind of looking at, okay, what are the pros and cons if I do that? So I've certainly been, I'm usually on, not always, but usually on for employer counsel. And I've certainly been in the experience where I've got somebody bringing a privacy complaint and a small claims court matter and a human rights tribunal suit all at the same time. And some of those bodies have mechanisms built in to kind of deal with that. So a lot of the human rights tribunals in their rules and the commissions will say, is there another proceeding, you know, arising out of these facts? And essentially, you know, if so, what do you want to do about that? So I think the default is, if you think you may want to bring that claim, you know, I would probably bring it in whatever forums you think are appropriate, and then you can sort out which one, how far you want to go in each one. You know, hopefully you'll just be able to sort it out, and you won't have to end up all the way down the road anywhere. But I think that's the thing to kind of look at is does it make sense to bring all these? And it depends on the resources of the client too. So there may be some clients that say, I want to do everything. I want to put really hard pressure on this employer, and I want to bring a claim everywhere I can, and I've got the resources to do it. And others might say, well, you know what, I don't have the kind of money or even like the emotional kind of resources to try to fight on all these different fronts at once. Let's just focus on whichever one we think is the strongest claim and is going to get me the most, kind of at the end of the day, or the remedy that I really want out of this. So I think those are the things to kind of think about, but great question.
So Elizabeth, thank you for that very practical and from the trenches response. Just before you continue, I just wanted to pick up on something you said earlier about special rules for certain types of employees, and just add on to what you implied, and that is under Yukon's Corrections Act, inmates who are in a work program as defined in the Act are considered employees for certain purposes. And however, they are exempt from certain legislation, such as the Employment Standards Act. That's all I'll say, though, and invite any of the listeners who are interested in this. They can look at Section 33 and Section 34 of the Corrections Act. And with that, let's continue.
All right, thanks for that, Tom. So what I've done to kind of help out a little bit, and I'm not going to go through them all in detail, but I have put together a couple of charts for you to get you started that basically sort of summarize the options. Just don't forget that they do overlap, and you're not necessarily just limited to just one venue. So I will find a way with Lynn to kind of make these available to you. But essentially what I've done is I've kind of summarized, what's the sort of general topic of the law? What is the kind of court or tribunal or administrative body that you might want to be looking at, and what's the statute that you might want to be looking at. So hopefully you will find that helpful. Just kind of quickly down the left-hand side. So, if we're looking at privacy, we've got inappropriate disclosure of an employee's personal information. That's you're going to the Office of the Privacy Commissioner of Canada. If you've got a breach of the employment contract. Now, this is all based on Yukon, so provincially regulated folks, you're going to have to do your own analysis on that front, but you can kind of follow the chart, I think. Failure to meet employment standards minimums, minimum pay, times for payment, statutory leaves of absence. Where do you go for that? Discrimination in employment. Lots of different places to look at that. One of the new ones there is the Accessibility Commissioner, which is going to be a subset of the Human Rights Commission for federally regulated employers. We don't know exactly what that's going to look like. They put the hiring notice out this summer for that position, and that'll be really interesting. There's an organization, there's a new piece of legislation called the Accessible Canada Act that will be being administered by the Accessibility Commissioner. So something to keep in mind if there are access issues involved in your case. And then procedural safeguards. I did have a little look at the Bill of Rights. It really is sort of focused on kind of more like what I would describe as kind of charter value type things. Not so much the employment world, but it does have some procedural safeguards. So if you find that your individual court or tribunal is not giving you the kind of procedural safeguards you need for your client, it doesn't take you very long. It's like a very, very short act. You might want to have a look at that to see if it's helpful. And then occupational health and safety. Generally speaking, you're either going to Yukon Workers' Compensation Health and Safety Board, or for federally regulated folks. Now this is, you get into some interesting things here because there are different ways that, the standards might be set out in one place, but then another body would actually kind of implement things. So that one, I'm quite lucky here because I have an occupational health and safety specialist. So I just call Richard for a lot of that stuff. But there's some things to think about if you have an occupational health and safety issue arising out of your case. And I put a little note there. Most occupational health and safety legislation also does include language around bullying and harassment. So you might need to consider the overlap with a constructive dismissal or human rights law if the bullying and harassment is based on a protected ground. So there you go. There's all your options. And then I've got one other little pitfall, and then I'm going to turn it over to Jocelyn. So my pitfall number 2 is forgetting the common law. So if people don't practice in the employment area a lot, they often either forget or they don't know to think about common law sort of rights and obligations. So essentially, employment is fundamentally a contractual relationship, but I sort of call it like a contractual relationship plus, because there are these different common law, both implied terms, and then you could probably get into a big dispute about fiduciary duty and what exactly is that, and is that an implied contractual term, or is it just a standalone restitutionary kind of thing? But that's more like a law school exam. The practical thing is you need to think about what are these other duties and obligations that might be implied by the law. And for the employer, the big thing is that it doesn't matter if you didn't talk about what was going to happen when the person's employment was terminated. You never thought about it. They never thought about it. Everything was hunky-dory at the beginning. But even if you didn't talk about it, and even if there's nothing in writing, you still have this duty to provide notice. So in the absence of just cause for dismissal, i.e. the employee's done something terrible that really, you can't be expected to continue to employ them. Assuming that hasn't happened, and that's a very high standard to meet, then if you want to have them move on, you're going to have to give them either notice in advance or a payment in lieu of that notice. And that is going to be considerably more than legislated minimums, particularly for senior employees or employees with really long service. And to give you kind of an example of that difference, across Canada, most of, not all, but most of the jurisdictions have a maximum of around 8 weeks of notice under the employment standards legislation. It gets a little bit higher in the federal jurisdiction, but you're still looking at not a ton. Whereas under the common law, if you have a long service employee with a lot of seniority, a senior executive who's been there for 25 years and kind of like worked their way up from the bottom, that person could be entitled to all kinds of notice. And when I say all kinds of notice, the Supreme Court of Canada has said the rougher upward limit is about 24 months, but we have seen in rare circumstances it go even as high as 30. And that is a big surprise if you thought you had to only give 8 weeks. It's a real shock to my American clients in particular, because they always think they have at-will employment. They can terminate whenever they want, basically for nothing. And so they just kind of look at me and go, what? Fortunately in Canada, we're a little more familiar with it. But if you're not practicing in this area, just don't forget the common law. The other thing, if you're getting asked for advice before someone dismisses someone, make sure they do it in a sensitive manner, because the manner of termination can lead to an award of compensatory or aggravated damages. And that's getting really challenging. I had a case earlier this year. We had a 7-day trial in the BC Supreme Court, we, based on previous law, we didn't really see it as like a compensatory damages kind of case. But the trial judge disagreed. The trial judge decided that the fact that this employee, based on the facts found in the trial, had been told that they were not a good manager and that they did not want him representing the company. That is what had been expressed to him during the termination, after the person had pushed. So originally the employee said, well, what are you talking about? Like, why am I getting terminated? I don't understand. And they initially tried to sort of say like, well, it's just one of those things. And it's, we don't need to get into the reasons for it. So the employee pushed, and finally they said, yeah, we don't think you're a good representative of the company. You're difficult to work with, and we don't want you here. We don't think you're good at representing us. And so that ended up, in this particular case, the trial judge found that the employer should have known that this was a very proud man, and that saying that to him would have caused significant damage to him. It's a bit challenging because as employer counsel, you're going, well, okay, you have a duty to be forthright about the termination, but you also have a duty to be not insensitive, and that's a very fine line to walk. And so I think it's a challenging one for employers, but basically do try to be as gentle as possible in the dismissal. The Supreme Court of Canada has said to us, we need to recognize that these are sensitive times, and so we need to handle those dismissals, kind of gently and with a lot of respect for the employee throughout the process. And that can extend to the litigation process as well. So allegations of just cause, if you're on the employer side that you abandon right at trial, those are probably going to be a big problem. So think about that, not just at the time of termination, but in how you conduct the litigation and what you say in your pleadings. So those are some of the kind of implied duties and contractual terms there. If you're on the employer side, going back here, there we go. If you're on the employer side and you're looking at your employee that you're concerned about what kind of behavior they have done, there are some implied obligations. So even if you don't have a contract with them or like a written contract, employees still owe you a duty of loyalty. They still have duties around confidential information. And depending on how senior they are, they may have fiduciary duties that they owe to the company as well. And that can go as far as, requiring them, either not to compete with you or certainly not to solicit your customers for a certain amount of time. So don't think just because we don't have a non-solicitation agreement or a confidentiality clause, we're totally up the creek. Depending on the level of employee, you may have some options there for kind of protecting yourself going forward. So the big takeaway from that is just don't look just at the Employment Standards Act and nothing further. You need to go further into that common law analysis as well. And now I'm going to turn it over to Jocelyn for pitfall number 3.
And Jocelyn, Tom here. Just before you jump in, I would just like to note a couple things. Thank you, Elizabeth, very much for for your presentation so far. I think we'll be coming back to you depending on what comes up in the chat room and so on. Just wanted to point out before Jocelyn proceeds is that not all lawyers appreciate as we do that one of the hottest areas of law practice in the last 18 months has been what you might call HR law. And of course, that's reflected today very well with 50 of you who are presently on this call. And without naming names, because that would be inappropriate, I can tell you that we've got students on this. We've got very senior lawyers on this. We have a JAG lawyer on this. We've got government lawyers. We've got private practice lawyers, lawyers who have a long history of advising First Nations. We have a former public service commissioner on the call. So you can see that there's a very wide interest. So with that, Jocelyn, take it away.
Thank you, Tom. And thank you, Elizabeth. And this next pitfall just dovetails quite nicely with what Elizabeth was just discussing with respect to employment standards and the common law duty to provide notice of termination when terminating an employee without cause. So pitfall number 3 is forgetting employment standards. So not only will forgetting employment standards get you into trouble, likely with Tom, it will also affect your contract of employment with the employee. So if there is a written contract of employment, it's very important to remember to meet or exceed statutory employment standards. Now, failing to do so can get you into all kinds of trouble, especially in Ontario. There hasn't been much case law, or if any, on this in Yukon, but we're getting all kinds of scary for employer messages from courts in Ontario when it comes to forgetting about employment standards minimums when drafting employment contracts. So there's a duty, common law duty, to provide reasonable notice of termination where termination occurs without cause. And the common law reasonable notice is going to be, in most cases, much more than the statutory minimums. Employers and employees can contract out of this common law reasonable notice. In an employment contract, this is commonly called a termination clause, which has been used quite frequently. There's all kinds of ways termination clauses can become unenforceable, but one of them is if they don't comply with employment standards minimums. So this is a big pitfall, and the key takeaway is to carefully review the applicable minimum standards requirements and ensure that each and every term of the contract meets or exceeds those minimums. So basically, one bad apple can ruin the whole contract, or, this is in Ontario at least, one term that's offside can ruin your whole termination clause. There's a recent decision, Waxdale versus Swigan North America, and this is again in Ontario. The Ontario Court of Appeal confirmed that even with a severability clause, if any part of a termination clause is unenforceable, it will affect the whole termination clause. So in this case, the employer ended up having to pay common law reasonable notice because one portion of their termination clause, which wasn't the portion that the employer was hoping to enforce, one portion of it did not meet or exceed the Ontario Employment Standards Act, and therefore the whole termination clause fell. And don't forget as well, with respect to federal jurisdiction employers, the Supreme Court of Canada decision in Wilson and Atomic Energy of Canada, in my mind, again, this is information, not advice, but it stands for the principle that you cannot contract out of an employee's right to an unjust dismissal claim under the Canada Labour Code if they qualify for such a claim. So there's just, unfortunately, for employers cannot contract out of that, out of the employee's right to make such a claim for unjust dismissal under the Canada Labour Code. And it's pretty rare that federal jurisdiction employees will end up in civil court, but it will happen where an employee, for example, is a manager or has missed the deadline to make an unjust dismissal claim. And don't forget about some lesser known clauses under the Canada Labour Code, such as Section 230 sub 1, which requires an employer not to alter any term or condition of employment during the notice period. Now, the notice period under the Canada Labour Code is only 2 weeks, but if an employer has a right to RSPs or pension, none of that can be affected during the notice period. And unfortunately for TFI International Inc. in Ontario, again, its employee Sager, even though the employee was a manager and they agreed to 3 months notice upon termination without cause, their termination clause was unenforceable because the employer didn't comply with that a little bit lesser known provision of the Canada Labour Code. And the employee was actually awarded 9 months of notice. So unless there are any questions, I'll move on to policies. So a lot of employers, especially bigger ones, will have can have pretty extensive human resources policy manuals. And they are useful if they are, first of all, of course, communicated to employees. And even better so if the employees have agreed to them. Secondly, they need to be applied and followed on a consistent basis. So if an employer fails to comply with their own policy manual, for example, when implementing progressive discipline, it will be difficult for the employer to rely on the progressive discipline in the event of termination. So the pitfall being, if you have a progressive discipline policy as an employer, you should advise your clients to follow it carefully. As a lawyer advising your clients, make sure you ask about these policies and ask whether or not they're communicated to employees, whether or not the employer has followed them on a consistent basis. Sometimes I say having a policy in some cases that is not complied with by the employer can be worse to having no policy at all. And then another issue with policies is when, for example, a termination clause is placed in the HR policy rather than in an employment contract itself. Those kinds of termination clauses, when they're in a HR policy, can be very difficult, if not impossible, to enforce. And further, there's all kinds of problems. All kinds of problems can arise when you have a termination clause in an HR policy and a termination clause in your employment contract, and they conflict. So keep them in one place, keep them in the employment contract with the employee. And yeah, basically, there's something else with respect to what you do need in an employment policy, where they can be useful, and where now it is necessary to have them in the Yukon, is under the new violence and harassment prevention regulation under the Occupational Health and Safety Act in the Yukon, which recently came into force in the Yukon. There's a requirement for a written policy statement and procedures respecting the prevention of violence and harassment. And there's also a similar requirement under the Canada Labor Code. So that's what's useful in a policy. But there can be more complicated, a convoluted, complicated HR policy is that's not consistently applied, can be very problematic for employers. And so those are some policy pitfalls. I'll pass it back over to you, Elizabeth, for your COVID special edition, mandatory vaccinations. Yeah.
Well, Jocelyn, so I'm going to jump in just before Elizabeth comes forward. I'm sure what's coming is mandatory vaccination. So I'm sure that all of the participants today will want to know what each of you think about that in the employment context, because after all, it is probably the most widely mentioned employer-employee issue in the country, certainly in the last 6 to 12 months. So I'll leave that to you to work that into your presentations if it isn't there already. Over to you, Elizabeth.
All right, sounds good. So pitfalls 5 through 7, COVID special edition. Yes, and the very first one, mandatory vaccination. I was joking around with Jocelyn when we were assigning the topics, and I said, I don't know, can I handle another mandatory vaccination question? I don't know. Okay, yes, we can, because we know this is important to people, and we know you're interested in it. So that's good. So we will talk about that. We're also going to look at improper layoffs. So this is kind of like lessons learned from the pandemic, or things to think about for the next pandemic. And then also working from home. So those are the 3 kind of pitfalls that we have to go over with you for that. So pitfall number 5, and I'm going to call it reactionary vaccination policies. So, you know, and this whole area of kind of mandatory vaccination is really balancing of rights and obligations, because on the one hand, you know, under occupational health and safety legislation and just kind of good workplace practices, you know, people want to keep their people safe. And that's where a lot of this drive for mandatory vaccination is coming from, because they want to protect people. And frankly, a lot of people are scared, and that includes, you know, managers as well. So, you know, but then those have to be balanced against, you know, essentially requiring an employee to, you know, obtain a medical procedure, and against existing rights under current contracts that also have to be respected, and privacy rights, and also human rights issues. So we're going to kind of touch on those all. Now, it is fairly high level, because I would say the really big takeaway on mandatory vaccination is this is not one size fits all, and is not one size fits all, particularly across the country. So, you know, we have, you know, in Ontario, you know, certain locations where mandatory vaccination is being strongly encouraged and is even arguably legally required in certain places and certain industries. Here in British Columbia, we have now mandatory vaccination in extended care homes. You don't have a choice. That is the law. If you are going to work in that care home, you have to be vaccinated. But for private sector bodies and people who are outside the healthcare industry, you know, it starts to get a lot more interesting. And it is, the analysis is very specific to that particular employer. What's the regime around the employer, and what industries are they in, what size of an operation it is, you know, how does the day-to-day workflow go? All of those things are going to have an impact on what you can kind of advise. So because of that, unfortunately, we have to stay fairly high level here. But so the first thing you need to think about is what is the impact on the current employment agreements or the current employment contracts? Probably unsurprisingly, most of you didn't build in. And if we go through a global pandemic, then you will be required to be vaccinated. We just didn't put that in the contracts. Nobody was thinking about it. This is the once in a lifetime event, hopefully. So, you know, requiring this as a condition of employment is a new term. And generally speaking, without sort of legislated authority to do so, you know, you're essentially asking your employees to undergo a health procedure. And so, you know, where the rubber kind of hits the road is if you put in this policy, all right, what are you going to do with the employee who says, well, no, I never had to be vaccinated before, and I'm not going to be vaccinated now. So generally speaking, I mean, my view is at this point, you know, we haven't seen a lot of these cases come through yet because it's still relatively new. We've seen some on testing and stuff, but not so much on the mandatory vaccination. You know, I don't think you're going to be able to terminate for just cause because someone refuses to get vaccinated, assuming there's no legislative requirement. I think you're in a different scenario if there's a legislative requirement that workers in that industry be vaccinated, but that's a very, very small group. I mean, one of the interesting things when the pandemic started, you know, in British Columbia, we have a lot of sort of labor relations decisions about you know, what they were calling mandatory vaccination, although it was never actually mandatory. You know, the strongest policy that we saw enforced in BC, at least, was what was called a vaccinate or mask policy with the nurses down here. And so that was upheld, but it really wasn't, it was just that you either got vaccinated or you had to wear a mask. So it wasn't truly a mandatory vaccination policy. So I think you would have a hard time convincing you know, a court or tribunal in the absence of legislation that this was just cause for termination. So for people outside of the Canada Labour Code regime, and you heard Jocelyn talk about unjust dismissal, and you basically can't dismiss certain kinds of employees without just cause. So outside of that scheme, if you're going to dismiss because someone refuses to get vaccinated, you know, you may have to be paying them severance. So then you're looking at, okay, well, you know, who are we going to end up having to get rid of? And if we've got, you know, 25 or 30 or 40-year service employees, that's going to cost us a lot of money to move them on their way if they refuse vaccination. So those are the kinds of things you have to be thinking about for your current employees. It's a little bit easier for those employees that are kind of coming in new to the organization, because you can add it as a term. But again, that's got privacy and human rights concerns, which we're going to kind of get into. On the privacy front, I throw out my vaccination status all the time. I'll tell you, I got AstraZeneca as the first one, I got Moderna as the second one, and I don't care if you want to know when it was and why I made those decisions. That doesn't even strike me as confidential, but it is actually considered private healthcare information, and certainly the privacy commissioners have been very clear that this is not only private personal information, it's also information that needs to be accorded, the highest level of protection as health information. So they've come out very strongly about that. So, just by virtue of putting in a vaccination program, obviously you're going to have to ask for information about who's vaccinated and who isn't. So you're starting to collect personal information, you're starting to use personal information, and then you better be really clear that you're going to be able to justify to the privacy commissioner why it was reasonable for you to ask for that kind of information. And so, the organization that has a number of people kind of out on like a packaging line or something like that, where they can't socially distance, they can't do their work from home, or maybe they're in an environment where it's difficult to wear masks, and there's going to be this kind of, they might be more justified from a privacy perspective in collecting that information and using that information to put in some kind of a vaccination program. If you're somebody in an office like mine, where it's a bunch of lawyers and assistants, we can work from home, we've got those resources, there's hardly anybody even actually in the office, we can wear masks, we can stay 6 feet from each other because it's a fairly good sized space, you're going to have a harder time starting to justify that information. So I think the key thing is always knowing, okay, when the privacy commissioner comes knocking, what are we going to say? Why is this really important in our specific business with our specific employee group? The second big thing are the human rights implications associated with mandatory vaccination. And this one is where it gets interesting, because the protected grounds in each jurisdiction can be a little bit different. But generally speaking, the sort of two big ones we're seeing are disability or religion. So, and sort of a couple comments on that. On the disability front, it's usually someone can't get vaccinated. There's some kind of medical reason, whether it be that they already, they're allergic to something that's in one of the vaccines, and there isn't anything that's suitable for them, or they're going through, a chemotherapy treatment or something else that already puts their immune system at risk, and their doctor says, you know what, we just don't want to hit you with anything else right now. We don't want to try to mount an immune response because you're not protected enough right now. And so there may be perfectly legitimate reasons why people cannot be vaccinated. And in that case, you're going to have to engage in that kind of accommodation analysis. So can we accommodate this person without suffering undue hardship? And I'm going to suggest to you that it's pretty rare circumstances that, most industries, you'll be able to accommodate that person and not require them to be vaccinated by either having them work from home, getting them to wear a mask, making them socially distance, making sure they're sanitizing their hands, putting all those, I don't know if you guys all have those little sort of arrows on the floor about where you can walk and where you shouldn't walk and all of that sort of stuff. Can you convince a human rights tribunal that you couldn't do those things and that those things were not, possible? You're in an interesting position if you have legislation that says your workers have to be vaccinated. I think that's a very different analysis than where you don't have that requirement. So those are some of the human rights kind of implications. None of the major religions have come out and said that they oppose vaccination. I know at our firm, we've quite recently got a letter from a church body that essentially said we are against vaccination for these reasons, and it was supporting an exemption for that, and we looked into it, and it you know, it looks a bit challenging. Those are challenging to kind of refute. It looks like a legitimate organization. You know, they have a structure, they have some reasons behind it. You know, you can agree or not agree, but it seems like a legitimately held belief. So that one again is you're going to have to be looking at that hardship analysis. Political belief is an interesting one. I had sort of assumed that political belief was not really so much in play, but one of my colleagues has said he's been doing some research on that, and he says it's not quite as clear as we might like. So if you're in a jurisdiction that has political belief as a protected ground, you might want to look into that as well. But those are kind of the big ones. So you need to think about those both on the kind of, you know, throughout the whole life cycle of this vaccination program or proposed program. Is we're asking people that are starting to work with us about this, and we're asking our current employees. So you've always got to think about that. So, I mean, the takeaway I think on the mandatory vaccination is, first of all, a completely mandatory vaccination is going to, I think, be very difficult to uphold. Mandatory vaccination with appropriate accommodation for people who can't be vaccinated for protected grounds reasons, you know, may be more reasonable, but still not without significant legal risks. You know, I don't think this is something you put in just willy-nilly. The other thing that you can consider is, I mean, fundamentally your goal is to provide a safe workplace. So, you know, keep looking at those other options. You know, consider your history in that workplace. Like, have we had, you know, 30 trillion COVID cases? Okay, well, you might have sort of a better reason to say we need mandatory vaccination in this particular workplace. If you haven't had any and you've been doing just fine with the measures you've had in place already, you're probably, it's going to be a harder sell if it gets challenged. So yeah, lots of other ways to look at it. You know, all the standard stuff we've been doing for the last year. You can look at programs to encourage employees to get vaccinated. You know, those are options as well. So you can look at sort of the carrot approach versus the stick. So, and I would encourage people to really look at that. And now some clients have told me, you know what, I don't care, we're just going to do it and we're going to see what happens and we're prepared to take the risks. And I say, okay, great. I got my little memo in saying here's the risks. And others have said, you know what, I don't want to be the test case. Like, we haven't had a lot of cases. I think we're okay. So we're just going to keep doing what we're doing. So it's going to be a very individual analysis. So that's mandatory vaccination. Any questions? Doesn't look like any questions on mandatory vaccination yet, but maybe at the end. And then I'll turn it over to Jocelyn to talk about layoffs.
And maybe just a few notes with respect to the vaccination policies. And I, of course, agree with Elizabeth on the gist of it. But when we were in the midst of the pandemic, you know, one thing that I did note to employers, the balancing of the safe workplace obligations with this risk of a human rights complaint or an unjust dismissal or wrongful dismissal complaint. And that was really for them to make that kind of decision at the end of the day. And you know, it seems a little bit far away now, but at the time, I also had a lot of feedback from employers who thought, well, I'm more concerned about employee safety than I am about a risk of a claim or a complaint. So, you know, we're going to take these steps, which I completely respect. They knew the risks. And so that was something pretty interesting and all new during the pandemic. And at the end of the day, you know, what are you going to do if your employee refuses to follow the vaccine policy? And that's the question for employers. Are they going to terminate the employee without cause? And if they are they prepared for the consequences? And some of them were. So that was really interesting. Improper layoffs is the next pitfall. So we got a lot of questions about layoffs. And a lot of questions about, well, you know, the Employment Standards Act or the Canada Labor Code says I can lay off somebody for a temporary, for a short period of time. It's a temporary layoff. It's not considered termination. So what's the problem? And the problem is, of course, the common law. If the employer and employee haven't agreed in advance, or if the employee hasn't agreed to the layoff, and by the first one, agreeing in advance, we would like to see that in employment contracts. So I'm actually revising my employment contracts to, in a lot of cases, provide for the possibility of layoff, because pre-COVID, unless you're in a certain industry, it was quite rare that we would include the layoff, reserve the layoff right for the employer for a temporary period, of course, complying with employment standards, minimum requirements, of course. But it was rare that we would reserve this right for the employer and set it out in your standard form of letter of offer. And this has become more of a norm now, because if this right isn't set out in the employment agreement beforehand, then the even a temporary layoff can give rise to a wrongful dismissal claim or an unjust dismissal claim, because it does affect a fundamental term of your employment agreement with the employee, which is to provide them with work and to pay them for the work. And so this is a fundamental term of your agreement with the employee. And if you haven't agreed as an employer in advance to the possibility of a layoff, then even a temporary layoff can give rise to all of the common law notice requirements, even if you're still okay under the Employment Standards Act and under the Canada Labor Code. So that is one of the pitfalls that we saw come up a few times, at least, in the Yukon. So that's it for improper layoffs.
Okay, and that takes us into our final pitfall of the day, pitfall number 7, forgetting that employees who are working from home are still in the workplace. And now, if the employee is in the same jurisdiction, you're looking at slightly different risks. So you're still having to think about protection of confidential information. So, I've seen a number of cases where employees started working from home, and then, of course, they're at home, they're just working like they would in the office. They're printing out confidential things and, client information, and it's just kind of all over their house. And next thing you know, every Tom, Dick, and Harry that comes over to visit is able to see that information. So that's, a significant concern. Also getting it back, if they end up being terminated, you're trying to implement or get that information back after the fact, which is not necessarily easy to do. So you need to be thinking about how are you going to protect the confidential information if the employees are working from home. The other thing is that, employment standards don't go away just because you're working from home. So you need to be thinking about how am I managing or, working hours, how are those getting recorded? How do I know what's kind of going on that front? How do I know that people are getting their breaks? Those kinds of things are still going to be important. And the other one is occupational health and safety. That still applies even if the person is home. So you've got to think about, what's the emergency plan if there's a problem. Down here in British Columbia, we have working in isolation rules. So if you're somebody who works from home, but maybe you live by yourself, you could be, there could be an extra requirement for your supervisor to call you every few hours to just make sure that you're okay. So lots of things to think about there. And I mean, I know when the pandemic first came out, and I shouldn't be too harsh because we were all trying to figure out, what on earth we were going to do. But here in BC, one of the first things that went up on our WorkSafe BC kind of board or website was all about the importance of the ergonomics of the office environment at home. And we were kind of looking at it going like, seriously, like we're in the middle of a pandemic, like, are we really worried about, is my back getting sore from sitting at the kitchen table? But at that point, we thought we'd be sitting at the kitchen table for 2 or 3 weeks, not for 18 months. So while I will confess to mocking that a little bit at the time, that is a legit concern. People do have tripping hazards, fall hazards. You could get into some really interesting and expensive jurisdictional arguments about whether injuries happened on employer time or not. And so those are things you need to think about. The other thing that's really fascinating, or allocation of costs with working from home, is also a really interesting one. I think that one's a little bit clearer in British Columbia than it is in some other jurisdictions. But that's something also to think about, who's kind of paying for what. And then it all gets exacerbated if you're working from home in another jurisdiction. So I was speaking with a client once, and we were talking about onboarding a new employee. And then this was an American client. And they said, well, so this employee, they're in Quebec. Is there something different about Quebec? Like, oh gosh. Yes. Okay. So first of all, our nice contract that we drafted for British Columbia to Jocelyn's earlier Pitfall didn't work in the civil law system at all. So all of a sudden, the contract was wrong. It's just a whole different ballgame when you're going into other jurisdictions. And then you kind of take that and then make it even worse by sending them internationally. So, you've got your nice little business in Whitehorse, and one of your employees is like, yeah, I'm just going to go work from my place in Skagway. Like, okay, well, all of a sudden now we have an international employee, who knows what laws in Alaska might apply, because a lot of employment-based laws are based on the jurisdiction of the province where the person is and where the work is being done. So I think a lot of employers have been assuming that, well, if I'm, Whitehorse-based, or I'm BC-based, or I'm Alberta-based, then that's where all my employees, regardless of where they may have gone, are based. But that's not necessarily the case. So you really need to think that through before somebody starts working in another jurisdiction. The other thing I'll just kind of highlight very briefly is taxation concerns, because you can kind of manage the source deduction issue, but the other big thing is you might be triggering, depending on how much authority the employee has, you might be triggering a permanent establishment in another jurisdiction and then start having to pay tax in that jurisdiction. So if you have senior managers who are working from another province, you need to really be thinking about that and thinking about, okay, what are we doing? So all of these things can be, managed, but you don't want to do it without thinking it through and putting a policy in place so that you know who's responsible for what and what are kind of going to be the parameters of this working from home grand experiment that we're all doing. So there you go. That's my pitfall number 7. And I think that brings us to the end of the pitfalls. Are there any questions? I think we have a very brief period for questions still.
Elizabeth, I'll just jump in to say that it's almost 20 after the hour, so we do have 10 minutes or so for any questions. I'm not seeing any questions in the chat room. So just to maybe get things going, I'll ask each of you if you have any general comments to make on another potential pitfall, and that is an employer drug and alcohol policy, or what is often now called a fitness for work policy. I know that's a whole subject unto itself, but I'll just ask if you have any general thoughts on that.
Oh yeah, that's a big one. I would say it's a little bit like the working from home or the mandatory vaccination. Don't jump in and throw it in there without knowing, kind of what you're trying to accomplish, and making sure that you kind of take into consideration, human rights kinds of concerns. That's sort of just at a high level. I don't know if Jocelyn has any other kind of thoughts on that.
Yeah, so in terms of those policies, and I think there's different levels, there's different standards for safety sensitive positions. So you also want to think about what your employees are doing and how dangerous their tasks are when you're dealing with alcohol and substance abuse policies. So. Yeah, but I see there are a few questions in the chat room and also the Q&A there, Tom.
Yeah, okay. So we have one from Bruce Wormsby. There's two questions, but let's go to Bruce's question. It came up first, and here it is. What about location? For example, a fly-in mining camp. You might have had zero, you might have low local transmission, but if you have a COVID case, it can be much more dangerous. So there's Bruce's question.
Jocelyn, do you want me to take that one, or do you want to take that one? What,
Yeah, I think maybe it has to do with the vaccination policy. Yeah, go
Yeah,
ahead.
I think that's where that sounded like to me where it was going to. And I think that sort of is one of the factors that can be taken into consideration. So if you're in a remote community where you don't have access to medical care, that's going to be a factor that I would say would start to sort of, push, if we kind of think about everything as sort of pushing one way or the other, that's one that's going to push towards, a mandatory vaccination policy being a little more justifiable. Yeah, so hopefully that helps.
In the interest of time, we'll keep moving. We have a question from Pippa Lawson, and this has more to do with work from home policy. So Elizabeth, it'll sound familiar to you. She says, in the work from home context, do employers have any duties re health and safety risks arising from solely the home context as opposed to the work context, such as unsafe entryway, spousal abuse, and so on?
Yeah, that's a great question. And I think where we go with that is basically trying to be, because I think the short answer is some of those things, some of the ergonomic things, some of the sort of tripping hazards, those kinds of things still can apply in the work from home context. And so I think the key thing in dealing with the employees or sort of setting out your policy is to kind of say and identify, okay, when we say the workplace, when you're working from home, what do we mean by that? So, do we need the employee? Is the employee going to have to, maybe they have a 3-story house? Are they going to have to check every single floor and make sure there's no tripping hazards on every floor? Or, do we ask them to designate a specific area as the workspace and then talk about the requirements within that workspace? And I think that's probably the easiest for most. But yeah, it gets really interesting about when you get that really blurred line between what's home and what's work.
Elizabeth, would you in the normal course of giving advice recommend to an employer that they have a written agreement with their employee who is working from home to cover off these sorts of things, including what is work, what is the workplace, and all the attendant responsibilities and expectations?
Absolutely, and I think I would specify, what kinds of obligations people have. So have a checklist, yes, that they sign off on. I have looked for tripping hazards. I have made sure that my electrical sockets are, my computer wires are not frayed. I think if you want the maximum protection, you've got to be fairly explicit about those kinds of things. And it goes, and I think I think as a general rule, you've got to think about how does working from home affect our policies? Because even when we're thinking about drug and alcohol policies, most of them say you won't have, drugs or alcohol in the workplace. Well, if I have a stash of pot or a bottle of wine in my house, probably my employer wouldn't ordinarily care. And so if there's you've got to sort of think about all those things about how is that going to apply? So then it's going to be very specific about, okay, well, while you're working, or, you're looking at that fitness for duty again. So yeah, it's a whole new kettle of fish, and it'll be very interesting because it seems pretty clear that working from home is here to stay. So.
And on that point, I should just note we have 2 more questions that have come in. So here's one from Matthew Woodley, who I'll get to his question. He says he congratulates the two of you on a great presentation. And then he says, my view has been that OH&S requirements are the strongest basis for mandatory vaccination policies as an engineering control, quote unquote, for workplace hazard. We have clients whose customers are telling them not to send any employees to the customer's sites if the employees are not vaccinated. Do you believe this assists in justifying a mandatory policy, or at least in requiring disclosure despite the privacy risks?
I'll take that one. I mean, I think certainly, that's employers that are going ahead are using that as the basis. And they're saying that it's the occupational health and safety piece that is driving it. I mean, I think even built into the question is a little bit of what other people are doing, that are kind of, driving this as well, in terms of what are your customers or your suppliers saying in terms of how they're going to interact with your employees, which also I think under, a human rights case called Shrink raises some really interesting kinds of things too that are probably beyond the scope of what we have time for today. But I don't know. I think it may be jurisdictionally dependent as well, because like in certain places, the kind of language about what the employer has to do to provide a safe workplace can vary. So here in British Columbia, it's not, you must provide a safe workplace. You have to take reasonable steps. So there's a little bit of, because nobody can guarantee an absolutely safe workplace. That wouldn't be fair to employers. You just can't do it. So it may, it's going to depend a little bit on the language in your individual jurisdiction, I think too. But yeah, certainly that is where people are going when they want to justify a policy. And again, easier to do in certain workplaces where you're working very closely with others and you can't socially distance than in a workplace that's a little more distant, and where those controls are kind of easier to put in place.
And I forget which section, Elizabeth, it is in UConn's Occupational Health and Safety Act, but it's an early section that speaks to both the duty to provide a safe workplace on employers, but there's also provisions in there about the duties of employees. But let's leave that, because there are two more sort of comments, quasi-questions. They're both from Darcy to Chuck. And the first one is, he says, exceptional program. Too bad the issues are so extensive that there are probably more questions than answers that can be presented in 90 minutes. And then his comment, quasi-question, reads, if the law can impose standards in work from home environments, does that not also imply a corresponding right to inspect and require changes to the homework environment? This looks like a slippery slope. Elizabeth, you've touched on this, but there it is. If you want to offer any other comment, we have about just under 2 minutes left.
Okay, so I'll keep it quick. Yeah, I think it is a really weird slippery slope. Like all of a sudden, does your manager get to come to your house because you've got some, they need to check your setup? I mean, good grief. I think our challenge is right now the law has not caught up with everything that's happened. So that'll be kind of the exciting thing to look for, in the next kind of couple of years as the law catches up to the whole, work from home situation. I think that'll be very interesting. So we'll look forward to seeing. Perhaps we can give you another presentation in a couple of years when we know more about what's actually going to happen and how, when those cases work themselves through the courts and tribunals.
And just before we go, yes, in fact, there could be a presentation just on best practices regarding work from home policies or alcohol and drug policies, but that's my obiter comment. Jocelyn, before we wrap this up, any final thoughts or ideas?
The work from home agreements are definitely a good idea, and that could address some of these questions. And basically, yeah, it's been a really interesting time for employment lawyers. So all kinds of novel questions and things that, you know, even though I was around during SARS, this just never came up before. So it's been really interesting. And thank you so much, everyone, for attending.
Well, thank you for that, Jocelyn. And you've just started the role of thank you. So I'd like to thank you, Jocelyn and Elizabeth, for your clear presentation today and giving us an overview on some of the hottest issues in HR law, both now and certainly over the last year or so. I'd like to also thank again the Law Society and in particular the Continuing Professional Development Committee for organizing this webinar. And finally, I'd like to thank all the participants today for tuning into this, and stay tuned for the next Law Society Yukon webinar. It'll come to you, notice of it will come to you through email. Take care, everybody. See you later. Goodbye.